Happy Sabbath. Good afternoon to you. I'd like us to stand for a word of prayer. Let's pray. Our Heavenly Father, we come before you this afternoon. We thank you for a wonderful Sabbath that we continue to enjoy. We now begin our afternoon session, and we place the topic and the speaker in your hands that you may lead, that all of us may learn something about putting our houses in order, and that this session will be a blessing to everyone. This is our prayer in Jesus' name. Welcome to this afternoon session. I'm glad you chose to come back. My name is Ken. It's a special Sabbath because today you get to have two Kens on the pulpit. One is better dressed than the other, so please forgive the other. I wish to read from Proverbs chapter 13. Please go there. Proverbs chapter 13, verse 22. Proverbs 13:22 says, "A good man leaves an inheritance for his children's children, but a sinner's wealth is stored up for the righteous." I'll read that again. A good man leaves an inheritance for his children's children, but a sinner's wealth is stored up for the righteous. May God bless the reading of his word. I'd like to invite my namesake, Elder Ken Nyaundi, to take us through the session. Thank you.
Good afternoon. I'm glad you came because I would have been speaking to myself if you didn't come. I have my legal team here. Do you want to come here? Please. We're going to have a discussion that is going to be, I think, very interactive, more like a Q&A. That's why I need you to do the answers. In the last 1 month, I have lost 2 friends who are also clans. One had a will, the other one didn't. The one who had a will had less education, if it matters, than the one who did. We're trying to put the affairs of both of them in some order, and I'm glad that the other one, had a will. That is as many facts as I can give you. So this afternoon we are going to discuss succession. Succession is basically the devolution of title in property from one person to another. In the morning I said that statistics have it that only 5% of Kenyans plan for their permanent absence. And we have sometimes what I think are cultural issues about planning for our absence, or sometimes fear, greed on our part, or sometimes actually recklessness. Recklessness of a kind that says, I don't really care what happens after I'm gone. So I'm going to have this session bring out the realities of our lives and give you real life examples. Of course, you know that because we are bound by client confidentiality, I will not tell you the names of the people, but every example I'm going to give you is a real life example. Now, succession to property may happen in two ways. It may happen either when you have provided for it in a document called a will, in which case it's called tested succession, or when you have not written a will and Justice Ogola is going to tell you what you should have done in a judgment, in something called intestate succession. Many of us here are old enough to remember S.M. Otieno, is it not? That, I think, it was the very public and open intestate succession that we all watched on TV from Justice Samuel Wosire's ruling to the drama that made Judge Richard Quach very popular. But just before I forget, there's something that the judges said in the Court of Appeal that you should remember. Put your finger there, like they say, and store it. They said that even when you write a will, you see, in a will, you confer property, okay? But the judges in the Court of Appeal said, and that is quite unlike the practice in other Commonwealth countries, they said that there is no property in a body. Sila. Property means there is no value, so that you cannot will your body. You understand? You can't say, and the court may not enforce a direction that I want to be buried in Kaputumo in Nandi. But judges respect that wish. So in the writing of wills, we usually say, I desire and direct, okay? That phrase, you'll see it a lot in wills. I desire and direct that when I die, I be buried in Nyakach, okay? Because there is no value in your body, so you cannot say, give it to so-and-so, okay? Or deal with it in any manner than that it is your desire. But in the African setup, many people put in regard the wishes of a deceased person. So all the time, most certainly people will take into account that desire, okay? So let me quickly discuss those two elements before we take questions. Now, when a person dies without a will, we have established that we say that that is intestate succession. But if your will is declared invalid, okay, for some reason that I'll show you in the third part of my presentation, then whether or not you had done a will, if the will is revoked, then your property will fall into the class of intestate, okay? But also, there may be situations where you have partial intestacy. In other words, a certain part of your will is valid, but some parts of it, with respect to certain properties, is revoked. So your estate, and when we talk about an estate, we are talking about the properties you have left upon your death. Your estate is governed partially as a tested estate and partially as intestate. Intested only with respect to the property that the will has been revoked. So there is total or partial intestacy. under the Law of Succession Act, the law recognizes dependents, okay? Those dependents are ranked in the law, the wife, the children, stepchildren, the parents, grandparents, in an order. So remember this, it's a dependent. Maybe that calls for an example. A few years ago, a client of mine passed on, unfortunately intestate, he didn't have a will. But this gentleman also was married, but he didn't have his own biological children. But in his lifetime, he had adopted 2 children of his late sister. He treated them as his children. When we went to the life policies that he had with some insurance policy, those children were listed as his own children. So we go to court to prove the intestate succession. 2 other children come in, but before you get excited, these 2 were not his also, okay? He didn't have children of his own. 2 other children come in with receipts from University of Makerere and said he paid our fees. Nobody in the family knew them, okay? Now, how he started doing that is probably not important for our purpose, but I cite that example to show you that these children who proved dependency also got a part of the estate because they were his dependents, okay? So they don't have to be biologically connected to you. All they have to show is that in your lifetime, you supported them. Why do I cite this example? To show you that when you neglect to write a will, you open your estate to as many people as can prove that they got something from you in your lifetime. So if you are writing and saying advantages of having a will, that is a one. Close in your estate. Let me go to the discussion I really want to have with you. Now, if we move from intestate, and there will be many questions on that, I'm happy these 2 are here. The judge is there, he will declare our submissions wrong and make a ruling. If you are not in the class of intestacy, then you are intestate. And this is what, and if a judge, as you said in the morning, in that story about the lady and the penguins, I've read it somewhere where it says that when she was releasing the penguins, because the person was asking, what difference have you made? She would say, I've made a difference to that one, okay? And I've made a difference to this one, okay? So even in this congregation, one person out of this presentation decides to write a will, I will say I've made a difference to that one. And let me say this, I think I will offer to do the first 5 wills free. The first 5, Ambassador. The other 5 who come, I'll charge them double to make up for the first 5. What is a will? A will is a document by which you direct how your property should be administered in your death, upon your death. It doesn't have to be in any particular format, okay? So long as it tells us what your intentions are, what your wishes are, what you would like done upon your death. Now, there are those people who fear that if I write a will and my children get to know about it, they will ensure that I depart earlier. really because the will takes effect only upon your death, correct? But you see, there's another way. If you write a will with me, or with any of the lawyers here, I think it's rare that anybody else would know that you have the will, okay? Wills are confidential documents, extremely confidential, okay? If there's a safe in any advocate's office, the will be in that safe, locked, under key, very safe, nobody will know about it. Least of all, the content of the will. So the guy who wants your soon departure might be the one who was least, so don't worry. They might want to give you time to make it differently. Now, because a will is a declaration of intention, it does not restrict how you deal with the properties while you're still alive, okay? So it is your property. You can deal with it whichever way you want until that day that you are not there, okay? Now, what happens, Brother Omire, if you write a will on Monday and on Tuesday you buy a car bigger than the one you drive now, although I don't think there is one bigger. A will is said to be ambulatory, okay? It takes care of the assets that you may acquire also after the writing. And the lawyers will usually put a clause in the will to say, any residual estate. In other words, we will provide for the things you have, okay? Anything which you own but which is not yet provided for falls into that class of residuary estate, okay? That too you can provide for, okay? So you don't have to write a will every day. You buy a property, you write a will, okay? Every day you buy a new car, you go to the lawyer to say, now I bought a new car. No. We have clauses in the will that take care of properties that you buy after writing the will. But of course, you can always also revoke the will, okay? You can revoke the will either by codicil, and I'm going to describe what a codicil is, or by writing a new will, because the first sentence in a will, usually, in a preamble says, I revoke all previous wills, okay? So don't say, I want to write next year, I'll be more prepared. So write the one you want to write today, okay? Revoke it next year when you want to write the new one. And I'm going to show you why really we must take this topic seriously, okay? So you want to write a will to deal with what you have today and revoke it or revise it by amendment through a codicil so that you have a one that is up to date. Now, wills may be either oral or written. And I think the older generation in the room will be more familiar with oral wills. In the traditional society, when an old man is about to die, he says, call my children. Is it not? Call my children. I want to give them my wishes. That's an oral will, okay? And he says, the land next to the river, I give it to so-and-so, okay? The one up the hill, I give it to so-and-so, okay? Now, the only condition that lawyers look at is that an oral will must be written within 3 months before you die. You must die within 3 months. An oral will, okay? Then it is valid. If it is outside the 3-month period, then we say it's not valid. Now, what is important also to remember is that an oral will must be made in the presence of at least 2 people, okay? So that they can say, yes, I heard him say this, and the other one, lawyers say, will collaborate. He will confirm that, yes, I was also there, and I heard him say this, okay? Otherwise, in the village there, sometimes if there are, say, 6 sons, one will call his son, say your grandfather has called you, and the two of them will go to the old man, and the son will tell the old man, now say what you wanted. You said that land next to the river I take, and the son of the grandchild says yes, okay? So they go to prove a will that is for their own benefit. The judges, Justice Ogola, if you go to him with that story, you will see through, okay? That yes, there are two witnesses, but this one was contrived. Now, the one I want to make more popular to us is a written will, okay? A document, and believe me, it doesn't have to be written by a lawyer in any language, okay? But it has to be in writing, signed by the person who is making the will, called a testator, the one making the will. And there have to be two witnesses to a written will. Now, suppose somebody is so sick, he can't sign it because, you know, we say a written will has to be signed. Somebody else can sign on his behalf. I think, again, going back a little bit in history, some of us remember the Ken Matiba against Moi case, where the judges said that the petition against Moi by Matiba would not survive because Matiba had not signed it. The law that time said the petitioner has to sign, okay? But we all knew at that time that Ken Matiba was incapable of signing, okay? And yet the highest court in the land said, if he has not signed it, it is not valid, okay? So the law has taken this into consideration, and we say that somebody else can sign a will for you if you are not able to sign, but when he does so, the two witnesses must be present to say that we were there when he told him to sign on his behalf, okay? What then happens if you want to amend the will? You prepare a document called a codicil. And the codicil does not amend the will fully, just certain parts of it. To say the land next to Lake Victoria, which I had given to my firstborn daughter, I now want to give it to my secondborn daughter. So the codicil deals only with that bit of property that you want to change. Everything else remains the same, okay? Then there is a privileged will. A privileged will is a will that has been given in less than ideal circumstances. And when I used to teach at the School of Law, this morning I met one of my students here. Is that guy around? I used to give them this example, okay, of a privileged will. A gentleman was out in the field plowing with a tractor. Out in the farm, alone, nobody within earshot, okay? The tractor rolled and crushed him. And while he was under the big tractor wheel, he took mud, which he had been plowing, and with that mud, he wrote on that mabati there, everything to mom. Everything to mom. That was a will, Now, there was no question that this was a privileged will. The question was, who is mom? Okay? Who is mom? Because he's left everything to mom, and he died. So the people who came to, rescue him, took pictures of that writing, and in an intestate succession contest, the mother of this guy said, everything to me. You see? The wife came and said, no, everything to me. Why everything to you? Because my husband always referred to me as mom. Children were there to say yes. In the house, dad always called mom, mom. They brought people from the club where they used to go, you know, Nairobi club and what kind of club. And they said yes, in our presence, okay? He always referred to his wife as mom, okay? And indeed everything to mom, the wife, except take care of the mother and the dependency. Not because everything goes to her, no. Because she was a dependent of this guy, okay? This is a privileged will. The other area where you find privileged wills a lot is in the military, okay? And for the military, by the way, the rule about an oral will surviving 3 months does not apply. Only in the military, okay? Where it is said that because military men are living almost always in apprehension of death, they can make their wills, and those wills survive the 3-month period. Now, how do you write a will? You write a will by setting down what you own and what you owe. What you own are, you know, assets and liabilities is what you own, your assets, what you owe, liabilities, you put them together, okay? We only require that for the will to be valid, you must have capacity. You must have capacity, and the capacity here means that you must be over 18 years old and of sound mind. What then are the contents of a will? It should have your name. It should have, as I've said, the bequests or the items you want to give away. Most importantly, it should have the name of an executor. In other words, you must nominate somebody who is going to ensure that your wishes are effected. It is not the lawyer writing the will. No, that's a different area. When you say, I want my property in Kileleshwa to be given to my last-born child, remember that this property is in your name. So there is going to be the person who ensures and who is going to sign on the ownership part for you to transfer when you have got an order from Justice Ogola, to take that order to the lands ministry officers, and the person who is going to sign on behalf of the owner by dint of the will and the court order is called an executor. Now, unless a will is signed by 2 or more witnesses, it will not be valid. But these witnesses must see, very important, there is a line we usually say there to say, we put there to say, I, as a witness, I was present and saw the testator sign the will. So, Elamunene, that witness will say that they saw you signing the will and they will put their signature there. A while ago, we used to say both of those witnesses must be present at the same time, but that's not a requirement now. But they must say that they saw you signing the will. Now, I have spoken about some of the benefits of a will, but I want to emphasize this now, that the creation of a will is an effective mechanism to minimize family disputes with respect to the sharing of your estate. Believe me, there are cases in court that have been going on for 30 plus years. Now, what I have found also very interesting is that the more wealthier the deceased, the more fierce the contest. You know, if you have a small plot in Oyugis there, 50 by 100, and another one in Kanyamukago there, the children don't even care about it. But if you have a house in Karen, another one in Runda, okay, they're going to fight. So the question you must settle with yourself is, would you like these children to fight in your absence? Or would you like at least to give a measure of control of what happens when you're not there? Who of us in the church this afternoon is sure they will not die? Who of us? You? This is not a laughing matter. We now must decide, okay, whether we want to assist the children or the dependents to share out our property. Because remember, we assume that with age and experience as a parent, you are more balanced in your view of things, okay? And I mean, look, I will say this. Today, under the new constitution, there is neither female nor male. Children are children, okay? And I have come across, I'm dealing with a matter of that nature now, where my deceased client had a large tea estate sealer in Nandi, okay? And there are 8 children, 5 girls and 3 boys, 2 boys who went to the US more than 20 years ago. One is around, 3 girls, the 5 girls are all married, but they were married around Nandi, very close to the father, always assisting him. They would go there and even help him to pay the workers because he was getting old. Now he's gone, and the boys have declared hallelujah. Even those ones in the US who have never really been of any assistance. And they're saying, remember you are girls. And remember you're married. But that does not matter, okay? Whether your daughter is married or not, you can still give her a share of your estate, okay? Parents in the room, that customary or traditional restriction we had is no longer there. You can deal with your properties in any manner you like. Now, under the will, okay, you can cater. Under intestacy, somebody has to prove dependency if they are not in your bloodline, okay? But under the will, you can give your property to whoever you wish. They don't have to be related to you, and nobody will come to challenge it so long as it is your wish, okay? I did a will for a client a while ago, and he had said in the will that property X, I will it to my neighbor, and the children were challenging it. Why would he give the property to the neighbor? And this was an old man whose wife had died a while ago. It came again to light through evidence that this neighbor, similarly old lady, was always at hand to help this old man, okay? You know, these children who don't live with you, they don't know that this old man would get home sometimes late at night. He was a wealthy man, okay? But there was this neighbor who was not so well to do, but she would send the children, enda mufungulie mzee, okay? Training, okay? Or there is some small problem at home, and the neighbors would go to assist him, okay? And he felt that he owed them, and he gave them something, okay? Now, can you do a will and completely leave out any of your children? Doing a will for an old man a while ago, and as we went down the property line, I could see that there was one particular son who he didn't give him much, okay? And so I wanted to be sure that this really are his true thoughts. And I went to him first time because he was unwell in the house, so I could only go and do the will in the house. Second time, third time, and I kept asking him, "Now who you, mzee? Who you? Tumuongeze?" Sema pana. Eventually he told me, "Hata hiyo nitachukua," you know. So I said to him, "Why?" Okay? Then he told me a very sad story about the relationship he had with the son, which was not a happy one. But I told him, no, tusichukue, because while you can give 70%, 30, or 70, 20, 10, if you leave him out completely, he has a very strong case for saying, me, I was not taken care of. But whether you do 80, 20, or 80, 10, 10, that is your wish, okay? So he really gave him a piece of land that, in my view, was like giving him nothing at all, okay? So it is up to you as the testator to make up your mind which way you want to go. I had said I wanted us to do this. Yes, I think I'm within the time I had in my mind. I want us to discuss this more, okay? But in closing, I want to say that there's another way. I don't know, maybe that doesn't apply to us here. There's another way by which you can waste your estate. You can waste your property. If you don't do a will, and nobody comes because they don't feel close enough to you, comes to seek intestate succession, your property will rank in the area. These lawyers will tell you, what is that concept? Bona vacantia. Okay? Ownerless. Property will be said, it has no owner, nobody, okay? It will. Now, in the early 90s, the Ministry of Lands went through a procedure of finding out why are the people not paying rates, okay, for certain properties. That was very rampant in Pangani, in Adams Arcadia, and they found out that for some of those properties, the last time rates were paid was in the 60s, okay? And you know what had happened? Those properties were owned by Asian families or Muzungu families who just packed up their boxes and went to Bombay or to London. Forgot about the properties, okay? Those properties were declared ownerless, okay? And I know a couple of people in this country who benefited. Go to the lands office and say, look, this one, nobody has paid rates for a long time. This property is ownerless, and they would have the property transferred to them. Today, there's something that started recently, the Unclaimed Assets Authority, okay? They look around for properties that there has been no action, and they say this one, the last time Omire paid the rates for it was in 81. Surely, for these many years, it must be that he has no interest in it, and you would lose property. I know of a gentleman, I will not give details because you might know him, who served in the Nakuru area in the 80s also, and owned quite a bit of property. But like all African men, he made sure none of his 3 wives knew. They had no business knowing. So when he died, the tenants who lived in those houses kept quiet. They didn't tell the families that we've been paying rent to your husband. They kept quiet, okay? With the time, they have had those properties registered in their names, because the properties now from the 80s until now is ownerless. There's another message I want to pass here, okay? To my fellow men. Amo, okay? Let your wife know what you own. Let your wife know what you own. Because there are men who believe that the properties they own is some state secret, stamped confidential for themselves. For who are you acquiring that property? Okay? If it remains in the realm of secrecy, nobody knows you own it, the danger you have is that should you pass away, it will go to strangers. Okay? So let the families, my fellow men, let the families know what you own. If I go to my office in the morning on Monday at 6:30 and I find 5 people there, those 5 wills will be free. And still I come to number 6, I'll charge him. So let's have a discussion around this. But I close by saying that I think we have come into a modern society where now these things are no longer strange. And when you write a will, you will not collapse tomorrow on the street and die because you have written a will, okay? We must move with the times and see the dangers inherent in our reluctance to write wills. In the mid-90s, the Public Affairs and Religious Liberty Department encouraged the writing of wills. You will allow me to keep referring to the people that I share history with, like Sila here. Sila, you remember that in Western Kenya at that time, there was a drive fueled by the General Conference, okay? And why the General Conference was interested in the writing of wills at that time was because they would say, when you write your will, leave something to the church. Yeah, leave something to the church, okay? In your will, you can say 10%, 20% of the money I have in Equity Bank at the Junction branch, I leave it to the church, okay? So there is that also. So when you start thinking about organizing your estate, remember too that there is that other of your dependents that are not so direct, and that is all these church members. Thank you very much, and let's have a discussion. Lillian, and come here. I'm going to ask Lillian to do the question and answer session.
Okay, thank you, Elder. That was a very concise and well-articulated presentation. So, church members, this is your docket. I'll give you time to, okay, I'll take 3 at a time so that we can give the lawyers time to answer your questions. So, Fora, number 1.
Thank you. I probably don't have much to write a will about now. But before, we are declaring that before I write a will, God will bless me. Now, 3 questions. How do you deal with co-ownership of property? Can I, if I am in the fund of, co-owning property, say, with my wife, would it be advisable that we jointly write the will? Have you come across instances where the husband shared property, co-owns a house, and then I decide I'll give my son the house, then my wife decides she will give the daughter? The other question is, I've seen several issues around death. at least in Western Kenya, bodies are cargo with value. So you find that people fight a lot about where somebody should be buried. Are there instances where the court can go against your wishes as the person? Recently, I had wind that a very good friend of my dad has decided to leave my dad with something. Now, if my dad does not, for example, write about the friend has decided to leave 5% of his estate with my dad. So what happens if my dad does not say, the 5% I'll get from my friend? Did you hear what happens with, or are you saying the will does also, you can't cross, you can't think about the property of somebody that is in another will? Thank you.
Well, I'm hoping the lawyers are jotting that down. So I think I'll take Maureen's, and then we can answer before I get to you, Elder.
Okay. My question is almost similar to him, but what I wanted to focus in, when he talked about the will, his presentation was more about an individual and men. I wanted clarity on where we come in as spouses or women on their own. Or is it this is a one-man show in terms of I do my own will on my own and he does his will on his own? And then goes back to his question, if they differ, then what happens? And remember, you only get to know about your will after one has died.
Okay.
Maureen, a will is individual, but it can be joint, okay? There can be a joint will, okay? Made by the husband and the wife together, but there will be a provision in that will to say, if I survive, this is the husband, if my wife survives me, okay, I will this to her. And the wife will sign on that same will, if my husband survives me. Now then you tell me, you want to ask me the question, suppose the two die in an accident, okay? What then happens, okay? What is then the rank of survivorship? Eh? The court will take time, okay? So I want to answer your question and Maureen's question in this way. There can be a joint will. The wife may make her individual will, and the husband his individual will. And you are not youth anymore. And for the youth, so long as you are over 18 years old, okay, anything you own that has value, you can will. Eh? And a will knows no male or female. Eh? It can be done by either person. Eh? Co-ownership. You will the part of the property that you own, okay? 50%, 20%, or 10%. That the shares you have in that property, you will. Otherwise, if you don't, then the property is succeeded under the concept of survivorship, okay? That the person who survives you then takes, it becomes fully their property, yeah? So, if you jointly own a property, you will the part that you own, eh? Now, let me say this, eh? At the risk of Judge overruling me, we make mistakes when we think that there's a relationship between burial law and succession law, okay? I read in the newspapers that a magistrate in Keroka has given an order to say, don't bury so-and-so until this dispute is cleared. Now, you know, the two wives are feuding over property, and the judge says, and the magistrate says, don't bury them until you agree. Now, there is no connection, okay? Burial law is burial law, okay? Governed by your individual customary law, okay? There is no way that keeping the person not buried is going to assist you. I was in a court, there used to be an old judge in Kisii called Patel, and there was such a dispute in court. It wasn't my dispute, other lawyers, and the judge asked those lawyers, so do you want to keep him unburied so he can come and give evidence? You know, where he wants to be buried, don't make those mistakes. If you come from a polygamous family, or for some reason somebody has died and there's a dispute, unless it's a dispute as to where he should be buried, it should not be a dispute about property. I see in the papers that people keep bodies unburied for 3 years as they are in court disputing over property in Kajiado when the person is being buried in Nyeri, okay? No connection whatsoever, okay? Except, of course, increasing your bills. Now, a will takes effect, as we said, upon the death of the person. So until that person who is giving your father, my friend, a property dies, your father does not own it. So your father can't will it, okay? You cannot will in anticipation. First of all, the question will come into, that will rise is, how did he know, okay? That so-and-so has left him something in a will so that he can also will it. He can't will it because he doesn't have it. Okay, any other questions?
Yeah. I've made some assumptions before that because we are of matrimonial property, that you cannot sell without the consent of your spouse, it means you are co-owning together or something of the sort. So I've always assumed that whatever a husband who has one wife owns, if it so happens that the man dies, if the property is in the name of the husband, it automatically relapses to the wife. That's my assumption. And when the wife dies, then now it can go to the children, and that's where the will comes. But in as far as my imagination is concerned, if you have one wife and you happen to die, then your wife becomes an automatic inheritor of all that you own until she wills to the children. I don't know.
Connected to this, I think there is a question of if you die intestate, what is the ranking of distribution? Is the wife an automatic successor or beneficiary? Because some time back I read that the wife is not an automatic inheritor.
Okay, who's taking over the mics?
Thanks, Elder Nyaundi. My question is, what happens when, I'm here, yeah. What happens when willing, or the parents use willing as a strategy for forcing cooperation and teamwork among a sibling? So they say that I'm not going to give people individual assets. So they're saying, you three boys who are feuding here, I'm going to give you this piece of land, all of you, find a way of working together.
Carry on.
Yeah, good afternoon, everyone. Yeah, my question is, if a person dies and they have properties, and some of the children are married, but there was no will written, what happens to the property?
Okay, I wanted to ask. My question is about debt. Assume my brother Mwaniki here 50,000, which I don't declare in my will. And then when they are now executing it, he turns up and demonstrates that Chami actually owed me. How is that treated? Yeah, I also wanted to ask.
Let Dr. answer those first, then we can continue.
Start with Chamia. Chamia, the liabilities of the estate are paid for out of the assets of the estate. That's why we said in the beginning that if you have a will, it has an assets and liabilities side. You declare the liabilities you have, and there will be a line in the will to say, all the liabilities that I have at the time of my death should be paid for from the assets before distribution. Okay? So that is not so difficult to deal with. Married children, my sister, we said earlier that today there's no distinction between male or female, married or unmarried. Okay? Now, if there is no will, okay, then you will go to court on an application for intestate succession. You will have the court to appoint an administrator, one or two, okay? Now, those administrators, and this is the mistake we make, we make this mistake all the time. I see people going to court and fighting. My brother has been appointed an administrator. I also want to be an administrator. I say, why? Okay? Because an administrator is not necessarily a beneficiary. You understand? So the law, the court will provide for the people to be administrators who stand in the position of an executor who will sign for the transfer, but the law also provides a very distinct column for beneficiaries, okay? And that is where you rank in your example. So the court will appoint the people who will administer, and then the court will provide for disposition in percentage or in the different bits of the properties to the beneficiaries. Recently, I have seen a gradual drive towards having properties left by parents placed in a trust, okay? So they say, we are not going to divide the property. We will put it in a trust, okay? In this trust, we will all administer. Now, if, as a parent, you have children who say less than what you think is ideal, then a trust is the best way to go. Because in a trust, you will have trustees, likely to be your friends, your age mates, who will make decisions over the properties for the benefit of the children. I have seen recently that parents come to me and say, I own a block of flats in Yaya Center, okay? The income from the flats, I want it to go into an account where the trustees will every 3 months release money to my children, okay? So that they don't get all of it and disappear in K1. That is an option you have. Create a trust. Let your properties go into the trust. Let the people you trust, okay, administer it on behalf of the children. Sometimes I have seen, and I have to keep coming to you, Sila, because we have a past, and nobody thinks I'm talking to you about specifically. I have seen old men say, I am not giving anything to my children. I have given them an education. Let them fend for themselves. But to my grandchildren, I am going to give. Okay? Very common amongst old men. Okay? I know an old man who is not my client at all, but we laugh about it on the court corridors. He's now old and a bit lost his memory and all that. He doesn't like his children at all, okay? But he takes the grandchildren in his very big car and drives around Nairobi with them and says to the 6-year-old children, that one is yours. The children don't understand, okay? That one is yours, eh? Because the old man says, my children have disappointed me, okay? But I want to take a chance with the grandchildren, okay? So he's overstepping them, and the law allows you to do that, and he's going to the grandchildren, eh? So that helps me to answer the question about parents enforcing cooperation, eh? I think that's a bright one, and I like it, eh? So what the old man is saying is, look, this is yours, deal with it, okay? And he's quite within his rights to do that, eh? Because he thinks maybe he has seen that you people don't quite like to do things together, which maybe is his wish, and he's throwing all of you into the pool, so to speak, and saying, you know, find your own swimming style, okay? But make it to the other end. So there's nothing wrong with that. He can will a property to 4, 5, 6 of you jointly, so that you deal with the property in a manner that you all accept. Ambassador, the Law of Succession Act actually has that ranking. Wife, children, parents, stepchildren, etc., etc. I can't quite remember the ranking. I know the wife is there, the children, okay? So that, however, does not help my brother Sila in your presupposition that everything you own will necessarily go to your wife. No, don't make that mistake, okay? When a time comes for people to challenge that concept which you hold, which is faulty, it will be your brothers, it will be your parents, okay? I know of a case right now, okay, where a gentleman passed on, left quite some properties, by the way, all over. And there are 2 children. The brothers are saying, and the mother says, you know, we struggled very much with your husband to pay his fees, okay? To get him to where he is, or he was, because he's passed on, we sold, you know, we went to cultivate in other people's farms to get an income to pay his fees. So she's explaining, and this is not irrational, okay? She's saying, we really struggled to get him to where he was. So they don't understand this concept that now everything he left goes to the wife. Okay. So I had a meeting with this lady, and I told her, you know what? Why do you want a fight? There's enough for everybody, okay? Just take what you think you need, because you don't need everything. You have 2 children. Tell your brothers-in-law, please take. Create peace in the family. Let them take. Because since this gentleman died intestate, if they go to court, and I gave that example about fees, and say, in his lifetime, he helped us in this way and that way and the other, a court of law might be inclined to give. So just give them out of your free will and create peace in the family, okay? So not only, Sila, not only your brothers, sisters, and parents, but even your children, okay? They don't understand that concept, that now dad is not there, everything is mom's, No, they want something. That story in the Bible about the child who came to his father and said, give me my share now, is not in the Bible for nothing. There are children. I know an old man who died. We buried him in Kitale. He had a son in the US who came for the burial, a daughter in South Africa who came, and her mourning style was to tell the mother, why don't you also die? So that we can take that things. These are not street stories, okay? this child is taking drugs, okay? She's no longer reasoning as you would want a child to reason, okay? So she's wishing her mother to die because the mother has now come between them and the properties that they desire to own. And in order to own, to sell, okay? I belong to a WhatsApp group where many of my friends who are about my age say, man, we better start living, okay? Because these properties you are so much struggling to acquire, when you are not there in the first 1 year, they will be on the classified part of the newspaper. Huh? So you are better off even trying to direct how they should be utilized in a will. I think that I've addressed matrimonial property. I think I've addressed everything. Could we take the last round? So
okay. I just want to ask Daddy for the question. Just the first one is will and last will. Because I noticed you talked about different types of wills. So maybe the difference. And then secondly, what happens if the executor dies before effecting the will? Say you write a will and 2 days later the executor dies. Who is supposed to execute then? And then lastly, is there a place for cultural dominance over the will? For example, if I buy land in Kitengela and I tell my wife that if I die, I want to be buried there, and the family on my death says that I need to be buried at home, maybe in Western, what happens? Can the family overrule the oral will, or what happens? Thank you.
Okay, the lady behind him. I don't know how many others.
There are lots.
Okay, so.
I wanted to
1,
ask.
2, 3, 4, Dr. Ree. Okay, five more people, and then I think we can wind up the session.
All right.
Okay, so 3 for now.
All right. I wanted to ask, what's the place of, there are times we're asked to write next of kin at workplaces. Now, if you die interstate and you've written next of kin, do they consider that? And what if you wrote next of kin and did not update? It's a going on case right now. Somebody wrote next of kin, separated with a wife, and now is married to somebody else. He's dead. Does the current wife, who is not listed down as next of kin, get the benefit from what he has? So next of kin.
Thank you, Elder, for covering this very emotive subject. Mine is a request, because I think you've covered enough on the side of the assets. Is it possible you can cover a little bit on the side of liabilities? Because this liability side has a nasty habit of upsetting the asset side. I say this because some families or most families in position of influence have a tendency of not paying taxes. And after the will is executed and the taxman comes calling, all the property which was willed to whoever they were gets swept off. So maybe it is important you cover a little more on this liability side. Thank you.
I have a small question also. Where I come from, the males, the men, well, the Lord made the male and female. No,
the men still have a problem accepting that the girls or the women can inherit something. So when the old man dies intestate, these men are unwilling to go to court. What can the women do? Because I see them at home. Can they force, can they go to court and maybe tell the court that they should execute because the brothers there or whoever, they have refused to go?
You are not describing a situation in Kenya. Where you come from? Now, anybody with an interest in an estate can apply. If you're talking about intestate, meaning somebody has died without a will, even the girls, married and unmarried, can apply, okay? Now, usually what happens is that when you apply, there is a form you fill which everybody with an interest in the estate is supposed to sign and say, I have no objection to the administration power being given to so-and-so, my sister, my brother. If they don't sign that form, you will apply, and then they will bring what Judge Ogola calls objection proceedings. They will come and say, no, she shouldn't be given the power to administer, we should be given, okay? Unfortunately, that's a situation you don't want, okay? Because then it will be left in the hands of the court to choose an administrator for you, okay? The ideal situation is this. If somebody, say a parent who owned property, has died intestate, the ideal position is the children should come together and agree to pick on administrators. 1, 2. And then they should agree on a benefit sharing ratio. If you agree on that, the administration is usually done within 9 months to 1 year, it's complete, okay? If you don't agree, then you stretch it, and the lawyers don't mind it, because you pay their rent. As you are quarreling, they are charging you a fee, okay? So the ideal situation really is to agree in the family as to how you are going to share. But finally, the short answer to your question is, you can apply. As a lady, you can apply. If this is your parent, you can apply. There is no bar to that. Laumire, an estate is shared net of liabilities. Okay? Now, in Nandi where I lived for a long time, I saw something there that I hadn't seen in Kisii where I grew up. At the time of burial, correct me if I'm wrong, Sila has left. At the time of burial, they ask, anybody here who is owed? Anybody here to support that? From that side? Correct? Elder, you have an assistant from. They ask, anybody here who is owed by the deceased? And you put up your hand, a very formal process, okay? And they note that down, okay? This is traditional liability asset accounting, okay? If you don't put up your hand, you hold your peace forever, correct? You can't come back after the burial and say, by the way, the deceased owed me 50,000. We do the accounts there before we bury, okay? We say, bring your claim so that we note it down, so that when we start Laumire sharing the estate, we have already removed that which is a liability. And even in the court process, we have an asset, as I said earlier, and liability side. And even if any of us wants to do a will, please remember that you will help your estate a lot if you identify your liabilities yourself. Don't let people start to come to court to say, you know, he owed me so much, okay? Because we don't know. And because you are not there, his evidence is going to be strong, okay? And a court of law may well accept that that is so, and the estate may lose. Next of kin, who asked that from there? Oh, now, those forms we sign, actually, I think they have changed a little bit. Next of kin is the old style. These days they write beneficiary, okay? Who is to benefit from this? And those forms are binding. They are in a way a form of a will themselves. And the property that has been, say, I take insurance, and in the insurance they say, if you are in an accident and you are not there tomorrow, who should benefit from the premiums, okay? The person written there is the person to benefit, okay? You are going to have a big job going to court to try and defeat that, because it is not necessarily that that benefit was given to you because you are a wife. No, the consideration may have been different, okay? So that even if there was a wife and now there is a wife, different people, the person whose name is there has a very strong case, okay? So it is up to us, again, when circumstances change, if we have taken, say, an insurance cover, or these unit trusts that are going around now, for us to direct a letter to that insurance or somebody to say that I've changed the person who should be a beneficiary. What happens, first of all, there was a question there about a living will and a last will, okay? There's only a last will, The living will is one that very rare these days, by the way, used to be there, okay? It's like a moving target, okay? You are saying this is what I own and I'll change it again, okay? But if you go into my brother's office, he's unlikely to do for you a living will. He will do for you a last will, okay? Because that creates less problems than something that we change all the time. Very good question. What happens if the executor dies before effecting the will? Before I answer that question, let me answer one of my own. What happens if I will a property to somebody today and that person dies tomorrow? Okay? In most wills, you will see a provision there that says these testaments, the benefits I'm referring to these people, will only be effective if they live 30 days after my own death. Okay? So that we don't have this situation where a will becomes transitory, okay? Where things are moving around and are in fluid. No. We want to give you a property if you are there 1 month after the death of the testator. But to answer your question, in the will, what I normally see is not that we will appoint 2 executors, okay? But somebody will say, if my executor dies before me, okay? Or if he dies before undertaking the process of execution, then the 2 witnesses to this will become executors. So it's something that is usually provided for, okay? Because this is a situation that is foreseen so that you don't leave the matter unattended. A difficult question, which you closed with. Cultural dominance as against the will. Now, we said this, I said this at the beginning, that in most wills, because of that statement by the Court of Appeal, I think that was Gisheru I don't remember who else was it, Kiumi, Nyarangi, and Nyarangi had a problem with that particular sentence in his will, because when he passed on, unfortunately, about 6 years after the SM Otieno case, we ended up burying him in a place where, if you asked me, he probably would have wanted to be buried. We took him to his village, etc. Because he said there's no property, so you can't make a definitive, inclusive direction. I must be buried here or there. Okay. Remember, the SM Otieno case is still binding to a large extent. That we are all bound by our cultural, our traditional, ways of life. A very unfortunate statement, if you asked me, that the Court of Appeal came up with. So that now, if anybody goes to court to say, my late husband wanted to be buried in Kajiado, and there is a clan from Huisero in Kakamega that says we want to take him there, then it is now becomes a court decision, okay? But as I said, the sentence you'll see in most wills is that I desire, but it's only a desire. It is not like saying I bequeath, okay? I give, okay, to so-and-so the property. About burial, you only tell us what your desire is. But as I mentioned, that desire is treated very seriously, okay? Let me mention something now while I'm there on the wills. You can make a will and say, and I've seen this in Nairobi here, with the parents whose children live in the UK, in the US, okay? A parent will say, my house in Kilimani, I give it to my son Kimani Njuguna if he relocates from the US. Becomes, okay? Otherwise he doesn't get it. My property in Narok, okay? I give it to my son if he is going to work on it, farm it, not to sell, okay? So this is what we said, that you still retain, because I don't want to sound morbid, okay? If I did, I would say that a will allows you to administer your property from your grave. That's saying it very badly, is it not? But that is it. Huh? You are still able to say, I want you to own this property only if you are going to do this and that with it. Huh? Some old man was telling me, he owns property here in Karen, that to my son so-and-so, I give him half of the property if he stops drinking. Very difficult, okay? I told him, suppose he stops today, he takes the property and starts tomorrow. In other words, there are things you can't say that are difficult to implement, is it not? Okay? But something like, I am giving it to you, if you come from the US back home here, is something you can effect. Because he's saying, I don't want to give you property which you are not going to use, okay? You're going to put a condition. Probably that is the point, that in the will, you can put a condition, okay? I am only giving him this if he does that, okay? I'll tell you, let me give you my last example on that. An old man said, the block of flats I have in Pangani, I give to my daughter if she is willing to forego her right to my property in Nyeri. Very good example. I'll tell you why this is a very good example. Because we are living at a time when culture and modernity are walking side by side, is it not? So other than having a married daughter go with her husband to build a house in her place of birth, but she's entitled. She can insist and go and build a house there. But he's saying, if she says, fine, half of the share of my father's land in Nyeri, I don't want, then only does she take the flats in Pangani, okay? And I found this a very ingenious way of dealing with this because Elder Nyandigisi, you are my neighbor. In some of these examples, like the one I'm going to give you, might recognize, where an old man says, my children, 4 of them, I have 40 acres here, 10, 10, 10, 10, okay? The girls are married, okay? Culture then comes into play, okay? The girl tells the husband, my father gave me land. Let's go and build there, okay? The husband says, no. You want me to go and live next to my mother-in-law every day in the morning, waking up and... There will be ways that we can deal with this clash of culture, okay, and modernity in a manner that does not defeat the legal stipulation that you are giving a married girl land in Siaya when she is married in Migori. My last example, I told you that this is going to be teaching by example. A lady is married. True story. A lady is married in Migori. Her husband passes on. Succession is done. She has 2 sons. Succession is done. She gets, of course, the property in Migori for her lifetime. As life would have it, husband's death, she meets a son who is widowed to live together. Okay? So she goes to her children and says, why don't we sell this land in Migori so that we go and live with stepfather so-and-so in Siaya? Of course the boys say no. Okay? They don't want to be uprooted like that. Okay? The boys come to me. One lives in the UK, one is in Nairobi. What do we do with our mother? Okay? The title is in her name. She wants to sell. She wants to take us to Siaya. Our father is buried in Migori. Okay? It's an ongoing case, so I will not give you much facts. But you see how we get confused. What would you advise, even as an elder of the church? Okay? These things are dicey. These things don't have solutions, but we must deal with them. Okay? Because when culture meets the constitution, or culture meets the law, then you are going to have a confusion in the family that you don't want to deal with. Of course, we say, until death do us part. Is it not, Lillian? Okay? So the mother is saying, death has caused us to part with your father. Okay? But I'm only 42 years old. So, I want to go to Siaya. I have met somebody, he has 3 children, you are 2, you have agreed to combine, okay? That arithmetic is not bad, But now you have a very distinct clash of culture and law, okay? Which is difficult to deal with unless you have anticipated it and provided for it. I will take the last 2 questions. Pastor is going to be very unhappy with me.
Thank you, Dr. I'm sorry to cut in on his session. He's my senior. I'm not supposed to do this, but I have been warned. And you can see it's 5 o'clock. I note that many of us have to attend other meetings. We are part of different departmental meetings. So before I wind up, I want to thank Dr. so much for this session. It has been very informative. On behalf of the church, what will you say to him? Yes, we just didn't want it to be a theoretical session. We wanted it to be very practical, and he's done that. thanks to his background as a teacher. So, and I'm very happy that he raised contemporary issues. As you can see, this new constitution opened with the Bill of Rights. It opened many issues. They're emerging. We are all cosmopolitan. Your son is studying in the US. You're living in Tanzania or whichever country. So these things are actually very pertinent to each and every one of us. So I don't know, I want to call somebody to come and, the AWM leader, kindly come and pray for us so that we wind up the session.
Okay, let us pray. Our loving Master above, we want to thank you greatly for the teachings of this afternoon. Dear Father, all that your children have gathered today, all that you have taught us, O Lord, through your servants, may you help us to put them into action. Bless all of us. All our challenges we leave unto thy able hands, that you lead us all through. The other sessions, the departments that we are now heading to, may you be with us until the close of the day. In Jesus' name we pray. Amen.
Hoo hoo.